Hi, welcome to Integrative Lawyers of the World, where we believe that lawyers are contributing to the healing of the world. And we believe this because we know lawyers who are doing just this. Hi, I'm your host, Carrie Raleigh, and our guest this episode is Marguerite Picard from Melbourne, Australia. Marguerite is a facilitator and peacemaker. She's an accredited specialist family lawyer, a collaborative practitioner, mediator, arbitrator, collaborative trainer. She has 3 businesses, MELCA, which stands for Melbourne Collaborative Alliance, Smart Separation, and Support for Lawyers. Her primary interest is in systems change away from the adversarial thinking to collaborative and interdisciplinary approach. Please join us in this conversation where she will share in her journey some tidbits she's learned along the way and how she believes that lawyers are an important part of society in the healing for themselves, for their families, and for the community. And if you like this episode, please like it, share it, comment on it. And check out our other episodes at www.integrativelaw.com. Hi, Marguerite. Thank you so much for joining us today.
Hi, Kerry. I'm delighted to be joining you.
Thank you. Would you like to start? Tell us a little bit about who you are.
Well, I'm a lawyer and I specialise in family law and have done so in about the last 20 years. And in about the last 15 years, I have been working only as a collaborative practitioner and I don't litigate anymore at all. I also work as a mediator. And most recently, I have started a business called Support for Lawyers, which is about support for lawyers' wellbeing and psychological health.
You've been a lawyer for 30 years. And you started, I believe, in criminal law, then did some litigation, and now you're a full-time collaborative. What has taken you along or helped you progress in that journey to the way that you did?
I guess like a lot of lawyers who do this sort of work that I do, I was experiencing increasing dissatisfaction in my work. It wasn't satisfying for me, and I was really worried about what was happening for clients. And that was mainly to do with working in the adversarial system. Well, I suppose it was primarily to do with that. And it was also about the fact that it was really difficult, unless you were part of a collaborative community, to work with lawyers who shared the vision and the idea about working outside the adversarial system, which I see as a step to a much greater system change, but an important step along the way. So for me, it was about my own well-being, but it was about the well-being of my clients and really shifting the focus of what we were doing to our clients. And when you work in the adversarial system, it's very hard not to be focusing on the system itself, the rules and the machinations and where you fit in that. And I think quite often the clients are just left as a bystander.
A Zen phrase that starts with healing in the individual, you have healing in the family. Healing in the family, you have healing in the community. Healing in the community, you have healing in the state. Healing in the state, you have peace in the world. And that sounds a little bit of what the journey is when you're starting the shift for yourself first, and then it carries over to your clients.
I haven't heard that before, but it's a perfect explanation or description of the journey that I'm trying to be on.
What is it about the adversarial system that, for lack of a better word, leaves a distaste in our collective mouths? It leaves a distaste in our mouth somewhat.
It's really hard to know where to start. It's such a long list. I guess for me, the first thing is that litigation doesn't actually resolve anything. And that seems to me to be a grand shame when people have spent years and a lot of money and they might get to a settlement, they might have a court order, but they're not actually resolved within themselves about the fairness or the common sense or the justice, however they might describe it. I think the fact that what we do in litigation is to say, let's drive people and their ideas and arguments as far apart as possible. So we put them at the complete polar ends of the earth. And then we say, now we're going to have a battle. And somewhere along the way, we encourage people to settle their cases, but we've done so much damage. So, I think when we're an adversarial lawyer, that is our job, to distinguish our client's argument, to elevate it to its best,
Mm.
for that to be a winning argument or series of arguments. But in so doing, I think it's necessary for us to demote any good motive and any strength in the argument of the opponent.
Yeah,
And so, it's a real Shark Tank, isn't it?
it is. And you see the way of, we always talk about the adversarial system in terms of litigation, but you also
Mm-hmm.
see like the adversarial way of thinking, and you see that in businesses of heighten my side to weaken to the other side, and the change of like the news stations and the way that journalists are presenting themselves, or opinion people are presenting themselves on the different outlets. And I remember looking like they're all acting like lawyers in a courtroom. How they're
Mm,
beefing up their side and using the,
mm,
the the language, the adversarial language, right? And
mm.
I guess, and I'm thinking that's not the way to go. Why are you doing it that way? At least the adversarial system was designed to be in a courtroom where you had both adversaries giving it their best, so that in the
Mm.
same time, the jury or the judge saw the whole picture. But now you're seeing that rhetoric being used on platforms where it's just one point in the heightened rhetoric without the rest of.
The context, yeah. I'd be the first person to say that the toxicity of the adversarial system flows out to so many more areas. So even if I'm in a supposedly cooperative negotiation, or maybe it's a high conflict negotiation, and there is the possibility that we'll end up in a courtroom, then everything I do is still in the shadow of the court, and maintains that adversarial overtone. I'm still being strategic and tactical in my conversations. It's not constructive and it's not based on trust. It's quite the opposite of those things.
Yeah.
And that for me is the great shame, that instead of working together to build the project of resolving a dispute, we're working together to dismantle the whole house, and then we have to find a way to rebuild something from the mess that we've made. And that's about money, it's about the cost to people, but I think it's more about the emotional cost, and the sense for most people that there was no fairness. The process doesn't feel fair to people
Yeah.
because there's more power or money on one side or the other. There's a perceived better legal team on one side or the other, or the judge is on the other side. But I think people feel if they've gone through a fair process, they can live with an outcome. But I don't think court very often feels fair for people. And I don't think people very often feel that when there's been a judgment, or they've been forced to come to a settlement along the way, that anything was resolved. They just signed a deal to get out of there.
When I worked as a litigator in a law firm, you know, I remember talking with a partner once, and we had a new case come in. It was, a couple, maybe a month or so we've had it. And at that time, I was already getting frustrated because, you reviewed the facts, reviewed the legal issues. And look, when it gets into a law firm and it's in litigation, it's in the gray area. Usually there's not a clear winning side. So it's a lawyer, you think, okay, this really, here are the issues, here are our weaknesses, here are our strengths. It should probably settle around, we should probably offer a settlement, it should probably be around this point. And the partner was like, we can't do that yet. And I'm like, why not? He's like, the parties aren't ready to settle there yet. Emotionally, they're not ready to settle there yet. They want us to fight and do this whatever litigation dance because they're angry and they want to fight. And it's only when they're worn down from fighting. This was years before I heard of collaborative law. And yes, it kind of makes sense, but isn't that at a disservice to the clients? And boy, don't the lawyers make a little bit of money in that protracted fight by having it become a
Yeah.
protracted fight. So,
But the shame of that, I think, is that there are so much more healthy and constructive ways to get people to the point where they're ready to settle.
yeah,
Instead of wearing them down and emptying their pockets into the lawyer's pockets,
yeah,
um, the point is probably valid. There is a point in the war of attrition where people will settle, but it doesn't mean they're resolved. And it doesn't mean if that couple are parents that they can walk away and in any way be effective as parents. And I think when we talk about what are the legal issues and the facts, they're things that land really hard for me, because I think that when we're talking about interpersonal disputes, there aren't too many facts.
hmm,
And we talk about the legal issues, and that's for us as lawyers to corral everything inside the legislation or the case law. You know, we're pretty good at turning everything into a legal issue. Give lawyers the space and we'll turn everything into law.
yeah,
You know, that's what I sometimes say to people, just, you know, try me. I'm a lawyer. I can turn anything into a legal
yeah,
argument. But it's the idea of arguing and isolating out issues. And for what purpose are we identifying issues and facts? It's because they provide us with ammunition, because we're preparing for a fight. Whereas if we turned to the future and said, what are our goals, whether they're combined or separate goals, and said, let's build the focus and build the foundation around achieving the goals, instead of isolating out the issues, which I think typically come from the past. And whilst we may need to acknowledge the past, it's not very helpful in moving forward to the future. It may be helpful in a legal fight. So, okay, there's a decision that's been made, but where does that leave the human beings? That's
yeah.
one of my many problems with litigation.
We started off with this as being your personal journey and your personal healing, and how that has led you for one of your businesses to actually create a business support for lawyers. Can you talk to us a little bit about that?
Sure. Well, this business is really new. It was only launched in March of this year, 2022. It was an idea that had been floating around in my mind for a long time. I guess it was seeded and informed by the fact that I've been working with counsellors, social workers, and psychologists in my collaborative work for such a long time. And I suppose I have deep admiration for their skills, but learnt much more about what they do. And I've also been part of a conversation internationally and locally about the things that are happening for lawyers. So, burnout, imposter syndrome, values clashes, not coping with billing, competition within firms, harassment, the whole litany of things that can happen, not just to lawyers either.
Yeah.
And some of the things that came up largely in research, anecdotal research particularly, was lawyers experiencing imposter syndrome.
What is imposter syndrome and how do lawyers experience it?
Well, I guess the idea of imposter syndrome is to think, I'm not really this person. I'm not as good as I need to look. You know, I'm about to make a mistake. I'll be found out. I'll be uncovered. How did I ever get this law degree and get this job? One day somebody's going to blow my cover, or I'm going to make a big mistake. And that sense that you have to be invulnerable, that in a way that you have to either know all things or you have to have access to the knowledge.
Yeah.
So huge levels of responsibility, and lots of lawyers feeling like they're maybe not up to the job.
Yeah.
But instead of reaching out like you might in other professions and roles and to say, I need some support and I need some help and some mentoring, that for whatever reason seems to be anathema in the legal profession. And I think it's a little bit different in the US from Australia, but our regulatory bodies typically aren't supportive. If we make a mistake, we can expect to be penalised and punished if somebody complains about us. So to me, it's kind of a continuation of the whole hierarchical adversarial system. It's patriarchal, it's hierarchical, it's punishing.
Yeah.
And we know what happens to lawyers who make mistakes. You know, it's career death. And so we're really careful not to make mistakes. So we're hiding behind whatever our armour looks like that makes us feel like we're an imposter inside that.
I think in the US system, it's that way too. Certainly in any state, the clients can file a malpractice lawsuit against you. And in addition
Mm.
to that, they can file a grievance each. And this where the severity may differ between the different jurisdictions, but each jurisdiction will have a bar association. Some bar associations are connected with the Supreme Court of that state that
Yes.
oversees the licenses of each attorneys. But someone files a grievance against you, it's investigated. You have to, I actually served on a grievance committee once, and the lawyer has to come in and present it, and it could lead to uh, sanctions and there could be disbarment. But if the findings are warranted, it is sanctioned, it is published, and you do, within the bar journal,
Mm.
in the court record. So it could be humiliating and scary if you have to go through something like that. And as a,
It's a great risk of shame, isn't there?
yeah, shame, that's the word
Um,
I was thinking of, shame. Yeah.
so that's one of the things that we know lawyers experience. But what really led me to starting support with lawyers was the experience that I'd had during the pandemic. We had very severe lockdowns in the state of the country where I live, and life was on Zoom and Teams almost exclusively for several years. And I'd probably been a practitioner who thought, I'm not sure about this mediating and collaborating and doing therapy on Zoom. But of course, we had no choice. So I became converted over and thought, well, here is the perfect tool for putting lawyers in touch with counsellors and therapists. And this is not only about crisis management, it's actually about supporting people in their day to day, in their goal setting, their coaching, momentary or longer term. And what our goal is really in this business is cultural change within law firms. So what we're aiming to do, the way people do it is they go online, they access a meeting through a calendar appointment, they pay for their meeting and they meet with their therapist. But what we're really trying to do, and we're starting to get some great uptake on this, is to have law firms buy packages. So you might have 10, 50 or 100 sessions in your bank, and every employee in your firm knows that there's a code that they can use to access the service. And above all else, what we heard, and I have heard for years, is people are terrified of being found out that they're accessing this kind of service.
Yes.
So this can be done on Zoom from the privacy of your own home. It's after hours, on weekends, at a time that suits you, but neither your manager nor HR or anybody else knows that you're accessing the service because you're just using your firm's code or token. And
And
that's
the
the
firm
same
won't,
token for everyone.
it's the same token for everyone. So the firm won't know who used the token. They just know that a token has been used.
That's right. And then when you run out of tokens, you top it up. But really, this is a message that we're hoping and expecting that law firms will send out to their staff, and not just their lawyer staff, but their support staff as well, to say, we're going beyond our OH&S obligations here. We actually really care about you and your well-being, and here is a service that you can access without judgment. And we think that that's a really important aspect of it, because we know that there's very modest uptake of employee assistance programs in law firms, for the reason that most lawyers are very concerned about their privacy. And I don't know what it's like in the US, but in Australia, the larger firms will have an employee assistance program, but middle-sized and smaller firms won't. And the majority of lawyers, in fact, work in sole and small practices, so they don't have anywhere to go. And many law societies and bar councils in this country, anyhow, are starting to provide some kind of a service. But I suspect, and the discussions I've had lead me to conclude, that people won't approach those organisations either, for the same reason that they won't go through their employee assistance program, because confidentiality is the thing that terrifies all lawyers.
Yeah.
And reaching out for support in a really healthy and constructive way is the message we're trying to send, as well as crisis management being available. But this is really about acknowledging that you are at your productive best when your well-being is being looked after. So from that point of view, employers have an investment
Hmm.
in making sure their employees are well and healthy and functioning at their best, for retention of staff, for making sure that people's relationships outside of work are stable and okay. Because, as all of us would know, if you're under incredible work or workplace pressure, you're probably not the best person to live with or to socialise with or to be in a family with.
Yeah.
So it's looking at the whole person.
When you were talking about the imposter syndrome, it's really weird, the timing of conversation. So just yesterday, I was having a conversation with a friend. She had hired a lawyer with regard to a family law issue, and she wanted me to look at the invoices and the timing and the time spent because it seemed like an extraordinarily high bill for the service. And she's like, is this fair, or do you see anything? I want to pay my bill, but I also feel like I'm being taken advantage of. Something doesn't seem right here. So that was the context of our conversation. And when we were in the middle of that conversation, I was talking about how when I was a lawyer, my biggest every review went like this: you're a great lawyer, great work product, the clients love you. Why are your billable hours so low? And
Yeah.
that's what I struggled with. And as I was looking at these other people's invoices, I saw things that they were billing for. And I'm like, well, I wouldn't bill for that. I wouldn't bill for that. That's not legal fees. That's administrative stuff. And so, there's part of the issue. But we also started talking about, because she and I uh, are friends. She's not a lawyer, but in my lawyer days, we lived in the same community and she was one of my good friends. But she's like, I'd always ask you to do something and you couldn't because you're working 80, 90 hours a week. But I knew this other lawyer who was out all the time. Every event, this other lawyer was there. And I remember thinking, how can this lawyer live this way and
Yeah.
you were living that way? And I think part of it was, I guess, how you're labeling it, maybe the imposter syndrome, because I was so afraid of making a mistake, that I always wanted to be so thorough, double check, triple check things, probably to the point of beyond of what was necessary to get the job done. But just because I was so afraid of not getting it right.
Well, I think billing pressures in all sorts of different ways are very significant in how lawyers live their lives, within their professional life anyway. And I think there's often such a values clash there. And I know there are many items that you can bill for as a lawyer. And I think I probably struggled in the same way as you're just describing, to think, what value did this actually add for the client? An unproductive phone call or whatever it was. And it's one of the reasons why, when we started Melka back in 2009, we determined that we were going to work in fixed price right from the beginning. So everybody is paid at the same rate, the lawyers, the social scientists, and the financial planners, which I must say came as a bit of a shock to the lawyers in the beginning, because it wasn't so much that other people's fees were being elevated as the lawyers were being asked to work at a more modest fee, because they weren't needing to do any marketing. There was no admin support required from them because we have a case manager, and it just allows the practitioners to do what they want to do. And I think most of us, when we become lawyers, don't have a business degree or a psych degree or whatever else it is that we really probably need
Yep.
to do all things. And so the pleasure of working on interdisciplinary teams means that burden of somehow trying to be all things or being seen to be all things to your clients is lifted. And I love it. A lot of people feel like it's a step in humility to give away your power, but it never felt like that for me. It was such a relief to share the power.
I think a lot of non-lawyers don't get necessarily all the responsibilities on a lawyer in a firm, or if you
Mm.
have your own business. You have the legal stuff, the legal expertise, but one partner made it very clear: we expect you to mind, find, and grind. We want you to mind your cases, the
Right.
legal thinking, the legal skills. You need to find new clients. You need to go out there, speaking engagements, volunteer stuff, networking to find the new clients. And then you actually need to grind out the work. You actually need to sit down. And doing that in an 8-hour workday it's not possible. You're expected to go to those networking events, give speeches that you have to prepare for, and
Yes.
you can work a 12-hour day and have, some days work a 12-hour day and only have 2 billable hours, but you're still expected to have the billable hours at the
Yeah.
end of the week. So I like
And
that.
I think it's that old-fashioned model where, you know, the investment in having the worker ants working as hard as possible sits with the top echelons. I think the fewest number of the people in the firm share the greatest amount of the profits. And we don't talk about anything other than the single bottom line. We don't think about the person who adds value to the workplace in various different ways. And I'm not just talking about rainmaking and bringing in clients, but, who's the good person to have around? Who sits and has the quiet moment with somebody who needs some mentoring? Who notices that someone's not doing so well or celebrates successes? Who literally brings in the birthday cake? And we don't talk about those things. And it's one of the things that I found really, really hard to effectively have the counting of the money coming before anything else, and I think lawyers talk much more about that than they talk about the client experience.
We are taking a brief break from this conversation to ask for your financial support. With each episode, we hope you can see how lawyers and peacemakers like you are contributing to the healing of the world. It takes many kinds of resources for the integrative law movement to keep going and affecting change. Your monetary donation can help us continue this important work by supporting the activities and the members of this community. Each contribution goes to promote the stability and accessibility of the movement and to support basic expenses like our Mighty Network group, web hosting, social media and event management, and this Integrative Lawyers of the World podcast. Because we like to give people choices, we have ongoing monthly options to match your budget, or you can make a one-time donation. Thanks to our non-profit corporate sponsor, the Renaissance Law Society, US supporters are able to make tax-deductible donations. Supporters from other countries, please check your local tax laws. For ways to support the integrative law movement and our world-changing work, go to our website at www.integrativelaw.com and click on Support the Movement tab at the top of the page. Another great way to support us is to rate us 5 stars and comment, like, follow or subscribe to us on iTunes, Spotify, Google, YouTube, or your favorite podcast platform. These ratings and interactions help us get seen and heard by even more people to make an even stronger impact. Thank you for your support and spending time with us today. Enjoy the rest of this conversation.
So one of the ways that with Melka, in addressing the issues with billable hours and trying to make it a more holistic approach is to offer a flat rate or flat fees. Can you explain how that works a little bit?
Yes, it's not a fixed or a flat fee that's the same for every family, but we have a defined 5-step process and certain components are priced the same regardless because the work is the same. And then we look at what the family needs, how much involvement is there going to be of each professional, but we don't count up hours. We have a range of fees that we expect most of our cases to fall within. And to be quite honest, most lawyers can do this when they've been working as long as I have. You kind of know what the value is. But the goal for our clients is that this money isn't just going to the lawyers. It's being shared amongst the financial professional, the case manager, the child specialist, the family consultant, and the lawyers. And so everybody on that team is equally important and is putting in the same way. And so we just talk about a project price. And, we did various different things in the early days. And we did do some weighing and checking against fixed costs and hourly rates and so on. But in the end, we have had a look at what it is that we're achieving for our clients. And, there are quite often clients who have all the willingness to be collaborative, but they really don't have much in the way of resources. And we will ask our practitioners, are they prepared to skinny down their fee a little bit in those cases? But essentially, the idea of a fixed price is bespoke for each family. It provides them with value. They know what it is up front. There's no mystery about the bills that are going to turn up. And also, what I really love about it is it gives a couple an opportunity to have a conversation about how they're going to fund the end of their marriage or relationship. Whereas normally, one person, the higher income earner or the better resourced one, might not think or worry too much about fees, and the other one will be really concerned about fees. And in our country, the rule is you pay your own fees. It's not a loser winner pays system here in Australia for family law. But generally speaking, the conversations we're able to have with clients is there's a cost to ending your marriage and reaching the agreements and doing the things you need to, in the same way there was a cost to your wedding, only we don't say that. But there is a cost, and regardless of who's the person who's articulated the end of the marriage or who is needing more or less of the resources from Melka, it's still a cost that the family needs to cover. And where's it going to come from? And to be honest, people just don't tend to argue about it. But if you were in the litigation system and you started talking to people about sharing the costs, it'd be an entirely different and less friendly conversation. But they can see the benefit for everyone in their family, for their kids, for each of themselves in a collaborative approach. And so we don't have any struggles with the idea of fixed pricing. People are really grateful for it.
Do you represent both spouses with Melka?
Melka is not a law firm. So the first thing that happens is the couple comes to us for an information session, and that's what we put out and we pitch. It's on our website. It's in all our marketing. Come along, have this session at a fixed fee and understand your process choices.
Okay.
And what we find is that if a couple is willing to at least do that together, that tells you a big story. And it might be that one or the other of them has already engaged with a different process or a different lawyer, and they have the opportunity to sit and think about whether they want to do something different. But mostly what we're encouraging people to do before they engage with any other professional is come and talk to us and understand what their choices are, with most emphasis around interdisciplinary work, because it's what we practice and what we believe in. And rarely enough does somebody say, well, we don't need you, we can work this out ourselves, because why would they be there? And rarely enough does somebody say, I want to go to court. People might say, I think we're going to end up in court. I'm not sure we can do this. So, of course, we talk about all the ways people can resolve their situation in that information meeting. And we then go on to the next step, which is where the couple meets the team and we put the team together. So we contract in all the professionals who work in our cases. And so at that intake or discovery meeting, each person meets with their own collaborative lawyer, privately, separately, independently. They spend some time separately and some together with the family consultant, who is known in the States mostly as a mental health professional.
Okay.
In collaborative cases, and some time separately with the financial planner. And the point of that started off in the early days actually as being to scope the work. But then we found that there was so much value in this discovery session for our clients as well as for us that it's, has a standalone value. And what we do is ask our clients to give their permission, and then the team meets to share what we've learned about what kind of support is this couple or family going to need to be successful in transitioning to two households. And our model is very much about screening in, not screening out. And that's where you might get some price differential. So if people need a lot of support around money coaching or therapeutic support, which would be done by referral out, if there's work to do on communication, end of the relationship, If the money story is very complex, if the assemblage of assets is complex, then we know that there's going to be more work and the project is bigger. So we start to have that discussion amongst the team at that point. And then we go on with building the foundation, negotiating, doing documents, and each stage has its own costing and price, but we can pretty much predict what the cost of the first 3 steps is in the average case and give people good information there. And when they've done those first 3 steps, it's a triage point. Are they staying with us? Are they collaborating? Are they mediating? What actually needs to happen to have a successful negotiation and finalisation of a legal settlement?
So do you have each stage for like the first step, is there like a project fee for step 1 and you get together, and then for step 2 they know this is what's going to happen in step 2, here's the project fee in step 2, and then as part of step 2 you kind of look together, going forward you will need this in step 3 and this will be the project fee for step 3 ahead of time. I can see that being so valuable to people. I have a couple of friends who were, were wealthy families and had to go through divorce. And one I know like personally firsthand, and one is a friend of my brother-in-law, but the same thing, they both came to the same time that they went through divorces and they have horrible regard for their lawyers after the fact because it was a coincidence. They couldn't make any headway with the other side. They're like, the lawyers, we gave them all our financial information to at the beginning because they need that through the process. And there's no budging or negotiation success until the financials get to the point where it's clear that we're running out of money. And only at that point are their negotiations successful.
People getting on with the job. Isn't that interesting?
And so,
well, we use,
and I was just going to say that made me very sad to hear. And it certainly can be something that those lawyers are doing. And it made me sad because I know there are so many good lawyers who don't do things like that. But it could also be the other side not wanting to, be able to have an emotional issue to it that's causing the fight to go on and on and on.
And that emotional issue could be the lawyers or the clients. But I think it's about lack of process. There is no process that guides negotiation between lawyers. It's an unguided nightmare in many cases. And if your lawyers have different assumptions, ideas and values, and if they're giving very different advice to each client, then it's predictably going to be a nightmare. So I think the idea of fixing fees is only feasible for the family as the family or the couple as a couple when you've got that collaborative approach to the fees. But I do know that a lot of conflict and mistrust and the increase in conflict happens around collecting financial data. I don't know whether it's the same the world over. I suspect it is. And we have a couple of companies in Australia which use artificial intelligence to collate the financial information. So in our collaborative cases, the financial planner is in charge of that. And because they're neutral, they don't get the pushback that individual lawyers get. But these artificial intelligence programs, by consent, the clients sign them and they will gather the data from the company's office, the banks, the tax office, put approximate values on real estates, vehicles, and all of those things. And to me, that's something that should be compulsory in any system because we know everyone has a duty of disclosure. So why are we making that so difficult and expensive? And it's we started off having the financial planner doing that work because we knew that was efficient and less kind of toxic than if it was being done between 2 lawyers. But now that we have this artificial intelligence in addition that we use, that's made a big difference. And now that it exists, I think it should just be uniform. We pay lip service and we allow people to subpoena and do all sorts of actions in the court in order to get financial information, and we've got an obvious solution that we don't use. So all of those things that we can do to make the client experience smoother, less high conflict, and cheaper, things that we're always looking out to try and engage with ideas that make it a different experience for our clients. And when we started Melka, that was our mantra. That's what we were trying to do. What does this feel like for our clients? And the consequence for me as a lawyer is it's been a much kinder way for me to work for myself. But I completely believe, and it's the bedrock, is that it's better for the clients.
Melbourne Collaborative Alliance, is it based just in Melbourne, Australia, or does it have other offices in other areas of Australia?
We have offices along the eastern seaboard, so Brisbane and Sydney. No reason why we can't do our cases anywhere else. But what we do is we don't send our staff or our contractors to those other cities. We case manage from Melbourne, and practitioners in those cities work locally with their clients.
Okay.
But working to our model. So having a model where there is a system and everyone understands the steps, the professionals understand the steps, the clients understand the steps, and their case managed so that we move from step to step and there's an understood process, I think just makes such a difference and such a huge difference to cost efficiency.
And this seems to be in a line. You have your third business, Smart Separation. How is that?
Yeah.
Is it a separate business? Is it related to the other ones?
Well, it's kind of related in that I need a practicing certificate in order to be able to practice as a lawyer in my collaborative cases. Okay. But Melka is not a law firm, and although I'm a director of that, I need to have a practicing certificate. So a few years ago, I sat back and I thought about where my strengths and interests lay, and I felt like it was on my interests were early diagnosis strategy, helping people to avoid the early missteps and to be part of a circle of trusted referrers. So Smart Separation has been established really as a triage and referral service. So somebody will come to see me, and what I'm trying to do is help them to find their way through the chaos. So I might initially send them to a divorce coach. They may go to couples counsellors. They may go see a mortgage broker, a financial planner. They may go to a mediator. They may go to collaborative practitioners, but they won't stay with me. So the point of it is that I'm able to give objective advice as a consultant because I have no vested interest in what it is that I recommend to my clients.
Okay.
So I moved from a more traditional legal practice to the triage and referral practice of Smart Separation, really for my own interests, because I didn't want ongoing cases that weren't in collaboration where I was in email and written communication endlessly with other lawyers, however cooperative that was. It just was not how I wanted to spend my days.
Yeah.
And I think very often people are really looking for one-off sound advice, and when they leave Smart Separation, they have an action plan, which is the things they need to do or not do, the referrals they're going to go and seek, introduction to referrers, etc. So it's setting them on the path.
I went to your website, and on the homepage it had, if you're thinking about separation, here are the right moves to make and here are the wrong moves. Can you just share a little bit about the right moves and then the wrong moves?
So the right moves are to think carefully about the advisors that you contact, to get recommendations from friends, to think about not starting with lawyers, to make sure that you're really clear in your own mind about what you want to do and how do you get clear. Do you meet with a therapist or a divorce coach? Identifying your own values. How are you going to have the conversation with your spouse? What help are you going to do to obtain to have that conversation? The timing, the compassion, the thoughts about your children that you'll have in those conversations. And some of the things I would say about the don't do is don't tell everyone except your spouse that you're leaving them before you do. Don't clean out the bank account. Don't be mean about money. Don't talk about your spouse and your situation to all and sundry. Yes, of course, you need to speak to your friends and close family. Make a decision that you want this to be a successful outcome for your whole family. make a decision that you want not to go to war, really.
Yeah.
But generally, I say to people, imagine that you have the starring role in a video, and this is now, you're in this video and you're going to look back at this in a couple of years' time. And do you want to be proud of how you were? You're allowed to stumble and fall and be sad and be angry, but try to be reasonable.
Yeah.
And God forbid that your children would ever see this video, but if they did, how would you feel about that? So, and it's trying to help people to develop a more positive idea that there is a positive future out there, whilst recognising that when I first meet people, they're rarely feeling positive. They're feeling all of the other things. But to know that there's hope, there are people to support you and help you, and to carve a pathway through this messy jungle of divorce, who to listen to, what to ignore, minimise all the horror stories or ignore them completely. And who do you speak to? Because quite often people will think my friend is telling me the best thing. And often what your friend is doing is telling you what you want to hear, which maybe isn't what you need to hear. So choosing your advisors wisely is one of the things that I suggest to people. And I feel like if they spend some time with me, that's one of the things that I can help them to do, to actually make those choices of an individual or a profession that they should look to first. So, yeah, my do's and don'ts list, I think, has really come out of all my years of practice and some of the awful things I've seen and some of the really heartwarming things that I've seen people do and decisions that they make at the start of separation, and try and help people bridge that divide and get over to the heartwarming side.
Can you think of an example of a heartwarming thing that someone has done that has left an imprint on you?
Oh, so many, actually. People saying to me, I really want him or her to be okay. And I know it's really important to him or her to stay in the house, or for the children to still be able to see my parents. They might be some examples. But making concessions that really hurt and cost you something because you're still honouring what you once had with your spouse.
Yeah.
To offer compassion, especially when I see somebody offer compassion and thoughtfulness in the midst of their own really deep pain, when they're suffering and they feel wronged and they feel that the situation's unfair, that they can elevate themselves above that and know that they still want to be a decent human being.
You have your 3 businesses, Melka, Smart Separation, and Support for Lawyers. What is your driving why?
My why in all of these is about system change. And I feel like each of them is an interim step along the way to making greater change. So I feel like Support for Lawyers is there to nurture and look after the lawyers until we have system change. Melka is there to model and teach people about conflict resolution so that they can stay outside the court system. And Smart Separation is kind of avoiding acrimony and avoiding the building of conflict. So what I'm hoping, and it probably won't happen in my lifetime, is that different ways of practicing law will gain so much weight and momentum that they'll balance out whatever is happening in the world of litigation and adversarial negotiation and the court system. And, it will eventually change. Systems do.
Yeah. And to transcend from there too, how I think the adversarial system from lawyers have leaked into corporate negotiations and leaked into our media and our news. Maybe this new way of lawyering, being more conscious and compassionate and wise, maybe that will also leak into the corporate negotiations, our media, and our news as well.
We do take up a lot of the oxygen, far too many lawyers in parliaments and governments, and we need to have different kind of lawyers in those positions if they're still going to be there.
What does integrative law or being an integrative lawyer mean to you?
For me, it's both personal and within the profession. So personally, it's about working in ways where my values are not at war with the system, where I feel like I am the person in my practice that I am in the rest of my life. And as far as the greater world and the system is concerned, to me, it's this fascinating network and web of people who in various different ways are making change until we become so big and so weighty that we can't be ignored.
Thank you so much for being part of Integrative Lawyers of the World. It was so nice meeting you here in Zoom, and I really enjoyed our conversation.
Thanks, Kerry. Likewise for me.